Jacob Graham, on the 22nd of February this year, you were convicted of terrorist offences by a jury after a trial which lasted over 5 weeks. Those offences were, firstly, of preparation of terrorist acts contrary to Section 5 of the Terrorism Act 2006, that was count 2 on the indictment. 3 offences of possession of a document for terrorist purposes, contrary to Section 58 of the Terrorism Act 2000, being counts 3 to 6, and 2 offences of dissemination of a terrorist publication, contrary to Section 2 of the 2006 Act. You are aged 20, being born on the 22nd of January 2004. During the time you committed these offences between May 2022 and May 2023, you lived with your mother, your sister, and her partner in the Norris Green area of Liverpool. You were a student and appeared to those who knew you to be an ordinary young man with an interest in fireworks, the military, and outdoor pursuits. You were aged 18 and 19. In reality, however, you were a dangerous young man. You described yourself as the first homegrown UK terrorist. It was only your uncertainty about whether someone else held that claim before you that caused you any doubts, because you were proud of that claim. You held a clear and settled intention to assist others to commit acts of terrorism. You searched the internet for information and files that explained how to make explosives, weapons, and ammunition for the purposes of terrorism. You collected a very substantial quantity of documents and videos which you provided to many others, whom you knew shared your interest in extremist activity and in planning terrorist acts. You even wrote your own document with step-by-step details of how to make explosives, ignition devices, weapons, the detonation of improvised explosive devices, IEDs, and how to treat law enforcement authorities. You called it Freedom Encyclopedia, and it was addressed to, quotes, to all you misfits, social nobodies, anarchists, terrorists, future and present, and anyone who wants to fight for freedom, close quote. Stand up, Jacob Graham. The sentence I impose on you is an extended sentence of detention in a young offenders institution for 18 years, comprised of 13 years in custody and an extension period of 5 years. The time you have served on remand is agreed at 290 days, which will be deducted from your custodial term, providing a period in custody of 12 years and 75 days. I impose concurrent sentences of 4 years detention, each on counts 3 to 6, and 8 years detention on counts 7 and 8, also to be served concurrently with all other sentences. Your extended sentence means that you must serve 2/3 of the custodial term before you apply for parole. It will be for the parole board to make the decision on your release up to the date you complete the custodial term. Upon your release and until the end of the extension period, you will be the subject of a licence, liable to recall if you breach its terms. You'll also be the subject of the notification requirements under Part 4 of the Counter-Terrorism Act 2008 for a period of 30 years. That means you must notify the authorities of essential information about you for that period, failure in which means you will commit a further offence. I also make a deprivation order under Section 23A of the Terrorism Act 2000 in respect of those items on the agreed schedule, which I am satisfied to the criminal standard have been or are intended to be used for the purposes of terrorism. I make a serious crime prevention order in the terms of the application for 5 years following your release from custody. Finally, you will pay the victim surcharge in the appropriate amount, which will be recorded on the court order for your sentence. Take him down.